And in terms of exposure for copyright infringement, which is one of the most common causes of action that are asserted here, you're really not, from a practical standpoint, they're one and the same. Copyright infringement is going to arise if there is unauthorized copying or display engaged by the bot. So if to do its work, the bot is storing even temporarily images of copyrighted material, or it's distributing it in any way, that if it's unauthorized, that would give rise to a cause of action for copyright infringement. To the extent that the bot has technical features that would allow it to defeat or overcome technical barriers that the website owner has erected to stop that kind of thing, that is also copyright infringement. It's a special version of copyright infringement called circumvention under what's called the Digital Millennium Copyright Act. Gets you to the same place. You're liable for copyright infringement. Why does copyright infringement matter? Your measure of damages, if you're on the hook for that, is disgorgement of all profits that you make through the copyright infringement. So if you are caught, you're not getting yourself anywhere with your business. You have the potential to be on the hook for the other side's attorney's fees, which is always a fate worse than death if they prevail. Even if you can't show, even if the other side can't show demonstrable damages, depending on if the copyright infringement is willful, you may be subject to what are called statutory damages, which is an artificial measure of damages of up to $150,000 per work infringed. So if there's a lot of copying going on, that can be very substantial. In addition, they can go in and get an injunction, that is an order from the court saying, stop, thou shalt not do whatever it is you're doing. And they can get impoundment of the infringing articles, so any copies, any of the apparatus you're using to do this. So it's a serious matter. And depending on the circumstances, executives, even though you have a company, you have a business entity upon which you're relying for cover from personal liability, there is ample precedent where it's been shown that a particular company executive directed and oversaw the infringing activity and profited from it. The court's imposing personal liability on a director or an officer of a company, and that comes as a shock sometimes, because you think you have an Inc., you have an LLC, you have something that's going to insulate you, not necessarily. The contributory and vicarious infringement, that refers to situations where you're not the first person infringer. Okay, so you're not the one executing the software that's actually in an application that's making the infringement. But for contributory infringement, if you give material aid or encouragement to the person that's doing it, you can be liable jointly and severally for that infringement. Vicarious infringement refers to where you're actually either profiting directly from it, or you're sort of almost involved in the actual enterprise that's doing it. So vicarious liability is a concept by which the employer of, in other contexts, it means the employer's liability for the bad acts of its employees. In this context, there's not an employment relationship required. It refers more loosely to, let's say, you're taking a cut. You have a deal with somebody who's going out and infringing. You say, you know what, I'm going to take 15% of what you make doing it. It's that kind of thing that would be vicarious infringement. And you have more of a possibility. What you have to think about here when you're making these bots and offering them is the manner in which you describe them and the manner in which you market them, and the practical uses they have. You've probably heard of the Grokster case. That was a file sharing case where the court found that company, Grokster, marketed it in such a way and said, look, use our product, nod, wink, wink. You'll be able to circumvent and you'll be able to rip these files. And in that kind of case, if you go far enough and you're explicit enough, you're on the hook for what somebody in Bulgaria downloads one of your bots, and if you're out there saying, you can use this bot to really clean up on XYZ social site, or really be a terror in such a virtual world, or slay all the dragons in Worlds of Warcraft in a way that's prohibited by those sites, you're increasing the chances that you'd be liable in that fashion by marketing it that way. Now, there is another area of exposure that is common in these types of cases, and it's breach of contract. When I say causes of action, what I mean is, the thing that ends up as a count in the complaint. You have this recitation of facts. The defendant did this, did that, and did the other thing. And at the end of the day, the complaint says, count 1, you infringed my copyright. Count 2, we had a contract and you breached it. Okay, breach of contract is a very common cause of action that we see in cases involving improper uses of bots, and it typically arises because the site or the stuff that the bot accessed was subject to some kind of EULA, some kind of terms of service, terms of use that form the contract. So it's typically a click wrap or whatever, or it might not even be a click-through rather, or it might just be displayed. You don't even have to click on it. But courts have pretty uniformly found that these types of agreements, the click-through and the website terms of service, are enforceable, and so that if you, even though they might, certain other provisions of these things like arbitration agreements and things from time to time aren't enforced, things like you can't be on this site for a commercial purpose, or you can only be on this site for such and such a purpose, right? And if that's different or other or contrary to what the reason that your bot is on that site, scraping data, or it's going and soliciting all the other users on that site in a way that's disruptive, or it doesn't even have to be disruptive. If it's prohibited and you're on there, the court is going to look at this as you have a contract, you have privity. Privity means that you are a party to a contract with somebody else, right? So I'm suggesting to you that if your bot is being deployed on a site that has a click-through license, you have privity. You're in you may be party to a contract if it's you directly, or if it's your third-party user. They're party to a contract with that website. Okay, so if your bot is violating the terms of service, right, that gives rise to a couple of things. Number one, it makes it very easy for them to show copyright infringement, because copyright infringement is unauthorized, and it is unauthorized. It has to, the copying and the display has to be unauthorized. Well, if they have an explicit contract that says you shall not do this, and you're doing it, it's unauthorized. So per se, they've got you for copyright infringement. It's a breach of contract. So to the extent that they can show damages, arising from your breach, you're on the hook for that. Now, two good pieces of news. I mean, I know it's not a lot of sunshine, but there aren't typically personal liability available. Contracts between two corporations are typically, the claims are not brought, typically are allowed to be brought against the principals of the corporation. And also, this is not a third-party type of thing. In other words, you're not going to get sued for breach of contract for what the third party does. However, the fact that the third party is breaching a contract, a wrongful act, and you're facilitating it, that's what gives rise to the other causes of action. So, what do I mean by other causes of action? Tortious interference with contractual relations. It's a tort that the formulation of which varies from state to state. Again, I'm primarily focusing on United States concepts here. But it arises where, without legal justification, you take some act to interfere with one party's